Thank you so much for joining us for this seminar on the practice of criminal laws during COVID. I just want to take a quick opportunity, in addition to thanking all of you for being here, to thanking our wonderful panelists this morning. We have Etienne Lesage, who is our Paris-based head of our Criminal Law Commission. We also have the wonderful Maria CRONIN joining us from London, and the wonderful Stéphane ELJARRAT from Canada, two of my favorite UIA members. I practice in this area of the law, so this seminar is particularly exciting for me. I'll be jumping off to give the floor to Etienne in a moment, but I just want to let everyone know that, as you have seen, we have confronted this situation aggressively. UIA has been extremely active. We've got webinars, podcasts, videos, LinkedIn, and every other social media site. I can't thank all the center as well as all of our members enough who have jumped in. I hope you all saw a special online edition of the Juriste, which had a number of very interesting articles about dealing with COVID, as well as our largest newsletter ever, which had contributions from members all over the world, as well as survey results on the rule of law and the state of the rule of law around the world. So we are doing everything we can to keep our organization active and thriving during this difficult time. Thank you to everybody. And with that, I am turning the floor over to Etienne to proceed with the panel. Thanks, everybody, and we'll talk soon.
Thank you very much, Jerry. Thank you very much, Mr. President of the UIA. You are a criminal lawyer, and you are the president of the UIA, and this is the first webinar of the Criminal Commission. And I think it's really important for us all, wherever we are, to share our expertise and our experience in this time of the COVID, which brought a complete change, transformation in our way of working. Because as criminal lawyers, we are used to go all around, all day long. We go to our office, we meet our clients, we host, we receive our clients, we go to courts every day, almost. We go to prison to meet our clients who are detained. We go to meet the magistrate and the judge wherever they are. So we spend our time traveling, moving, being everywhere we are needed. Now it's a complete change because we are forced to stay home. Some of us go to their office if they can, if it's not too dangerous, if their laws permits them to go. I personally go 3 times a week to my office to check everything, but there is no one there except 2 or 3 lawyers among 18 who are working usually in the office. So we will this afternoon, this morning, for those in Canada, like Stéphane, or in the US, like Jerry, or like wherever you are and that you are following us. And the point is to exchange our experience and how we face the challenging laws that are passed by our different governments, by our different parliaments, to face this exceptional state of sanitary emergency. In France, we had 19 ordinances, that means laws passed without the parliament, but with the force of a law passed by parliament. 19 ordinances on the 25th of March. So at the beginning of the confinement, just a few days after we were confined at home on March the 19th. So the government didn't lose its time to pass many laws, and particularly in the criminal matter, in criminal proceedings, to face this exceptional challenge that we all face. but that restrains drastically our liberties and the rights of our clients who are sued, who are detained, who are no more access to their lawyers because of the situation. And we, where we are, have made many requests all over the world, especially in France, against the laws that were passed to contest these exceptional rules that happens very often. These exceptional rules that are supposed to become permanent. When the state of emergency is over, sometimes the government wants to maintain some of the exceptional decisions that restrains some of our liberties, some liberties of the people we are assisting, we are hired for. So we had a previous seminar 2 hours before this afternoon in French with Véronique Moissinac from the Paris Bar and Claude Nicati from the Neuchâtel Bar in Switzerland. And we had a rapid tour of all the situation there and there. In Swiss, they're much wiser than we are, and they respect much more the liberty of the people and of the people who are brought to court. Now we're going to focus on the situation in the UK with Maria CRONIN, who is the president of the UK National Committee of the UIA, who is also the former chair of the Criminal Commission for the last 5 years or 3 years, don't know, remember. And Maria, you are going to explain how things are going in your firm, how you deal with your colleagues and with your clients. And then we will have Stéphane, ELJARRAT from Canada, who will expose the same situation from the Canadian point of view. So please, Maria, if you want to take the floor. I said to all the participants to this seminar, I see we are 54 now, that you can ask questions. And on the right-hand side of your screen, you have a question where you can put your question, write your question, and write your name. So at the end of the intervention of Maria and Stefan, I can give you I can read your question, say who you are, and if you want to participate and take the floor, with Colette Surin, thanks to Colette, that you all probably know, was the permanent of the UIA, who organized all these seminars and who is working a lot because she is organizing all the seminars made by our 40 commissions. Thank you, Colette, very much. You can take the floor through Colette to share your own expertise. So please, Maria, please take the floor.
Thank you, Etienne, and thank you, Jerry, for the introduction. Good afternoon, everyone. I hope you're all staying safe and well. Feels somewhat surreal to be speaking to a screen rather than a room full of participants, but with current events as they are for now, this seems to be part and parcel of the new norm. I hope not forever, but at least for now. From the UK perspective, at one stage, the COVID-19 crisis was so fast moving that it's simply impossible to keep up with what was happening in the UK context, or rather not happening in the criminal justice context. There were so many unknowns: whether hearings would continue, would jury trials be replaced temporarily, how would access to justice and to our clients be maintained, and how would open justice be guaranteed? And quite frankly, how would the system cope with further delays when it's already at breaking point? Following the effective lockdown in the UK on the 23rd of March, the criminal justice system has had to modernise and adapt in an unprecedented manner, and it's done that in a number of ways. What I will try and set out are the main changes and whether these give rise to concerns regarding access to justice, fairness, and whether open justice can indeed still be achieved. If I have time, I will also touch upon some of the concerning byproducts of the lockdown, which Etienne has also touched upon, with concerning restrictions on our liberties and on our rights. I should first note that civil hearings are largely proceeding remotely without the need for any changes to legislation. The primary change to the law in respect of the civil system in the context of access to justice has been to the extent to which proceedings may be broadcast and whether these fulfill the requirements of open justice. In my view, the civil justice system was already far more advanced, perhaps unsurprisingly, from a technological point of view than the criminal justice system. And as a result, the concerns about fairness and access are perhaps less acute. In fact, my civil colleagues even wonder whether remote civil hearings may be the way forward once this crisis is over. Turning to the criminal justice system, the current crisis has exposed the technological shortcomings and just general shortcomings in the criminal justice system. Whilst there was previously the ability for individuals to participate in proceedings remotely, this remained limited to defendants in custody for simple, straightforward procedural hearings, and in certain circumstances for witnesses to give evidence via LiveLink. Now, I'm going to be referring to LiveLink a lot today. LiveLink is a requirement whereby the person should be able to see and hear and to be seen and heard by the court.
Maria, excuse me, not
Oh, yeah.
to interrupt you, because we have a question of Robert Hurst, who said that your voice is distorted. Could you possibly adjust your microphone? Maybe it's just Robert Hurst. I don't know for the other participants.
Let me try again. Is that any better?
For me, it's okay, but for you, I'm waiting for a message of Robert Hurst and other people, but it's very good now. Yes.
Okay.
Thank you, Maya. Thank you very much. Please go on.
Just to prove my point about technology and the criminal justice system, I'm a prime example. The Coronavirus Act 2020, which is the main act introduced to restrict the free movement of individuals during lockdown and enforce screening of potentially infectious individuals, also introduced some significant changes to the criminal justice system. These were necessarily introduced with haste, without proper scrutiny and proper consideration. The Act amended in particular the legislation on live links, which I've just referred to, extending it to anyone involved in the criminal trial who's giving evidence or otherwise participating, including the judge. It further extended the range of criminal proceedings to which the section applied to include jury trials, appeals from the magistrates' court, which is the lowest court in the UK, and in applications relating to fitness to plead. And the amendment substantially increased the availability of live links as well at all stages of the court proceedings, and not just procedural issues. They also introduced audio links, which are effectively hearings by telephone. I don't know why they have to give them fancy names, but audio links rather than telephone conference calls. But jurors were accepted from the amendment, and their physical presence in court is still required. And that's important for a number of reasons, and I'll come to that in just a moment. Safeguards were, of course, included in the Act in line with the previous law, and there is now an express inclusion in the law to consider whether effective participation of the person to appear via LiveLink is possible. And I'll come to an example of that in the extradition context shortly. Further safeguards included provisions that a defendant may not give evidence by audio link, by telephone. Witnesses may not give evidence by audio link save for where video link is unavailable and all parties agree. And there are limitations on the type of hearings which may be conducted wholly via live link. And only certain minor hearings, such as hearings following conviction to vary bail, which is when you're remanded in prison, in addition to minor incidental preparatory hearings, can be conducted wholly via audio link. So, for example, on Monday, I had an audio link hearing simply to agree directions for one of my cases and to secure a date for the hearing if that hearing goes ahead.
So the conduct of remote hearings does have implications for the principle of open justice, both in the civil, in my view, and the criminal context. The role of the physical courtroom has been embedded as a central principle of open justice, and the shift to remote hearings presents a number of challenges to this principle, some of which are more negligible or less negligible than others. First, absence a court-approved live stream or broadcast at the time of the hearing, there will be no hearing in public and so no compliance with open justice principles unless after the event availability of a video or audio recording is an acceptable proxy. And again, that needs to be considered and decided in advance. Second, there is less transparency as to the content of proceedings, as specialist court reporters who would normally tour the courts to see whether something of interest is unfolding will not be doing that, and it's impossible to see from a simple cause list whether there will be matters of interest on which reports should be made. Third, there's no opportunity for intervention or participation beyond those identified in advance. And finally, there are also quite significant concerns whether remote hearings provide defendants with adequate access to their legal representatives and to the evidence, and therefore to a fair process. So let me give you a few examples where this is exemplified. So in the context of extradition hearings, which I mentioned briefly before, the Act makes provision for extradition hearings to be heard via live link, so video. That is both requests under Part 1 of our Extradition Act, so European extradition warrants, and perhaps more surprisingly in relation to Part 2, which is requests that we receive from designated countries. And that includes countries such as the Russian Federation, which are known for making politically motivated requests. In these cases, issues of whether there can be effective participation and fairness will be key. And please say if I'm speaking too quickly or if there are any points you would like me to clarify. So for example, not one of my cases, but the lawyer for WikiLeaks founder Julian Assange cited an inability to take instructions from his client while the prison was and remains in lockdown. So as you will know, Assange is subject to an extradition request from the United States. And at the end of April, his extradition hearing was postponed for up to 6 months after both his counsel and the prosecution agreed that it no longer was in the interest of justice to try him. He would have been tried this month. So the lawyers for Assange submitted that holding the trial via live link, which is possible, was unsafe, and particularly at a time when prisons are themselves struggling to contain the virus, and in circumstances where he is in particular deemed in an at-risk category. Interestingly, the hearing at which that was decided was done by audio link, and observers and journalists were able to dial in to the hour-long court hearing at Westminster Magistrates Court. Unfortunately, much with my own technological shortcomings, the observers and the journalists were unable to hear what the lawyers were saying, even when the court clerk was repeating the words of the defence barrister on behalf of Assange. And as for the impact, so Assange will be required to remain in a high security prison during this extended period, up to 6 months, maybe longer, in circumstances where his lawyers believe his mental and physical well-being is at risk. And for, more generally, there are concerns about a defendant's access to evidence to enable them to actually meaningfully follow proceedings and the ability to instruct and speak to their lawyers during those proceedings. All of these raise significant access to justice concerns in extradition cases in particular, which can involve significant interference with the rights of individuals and their freedoms. Now, another concern relates to jury trials. Now, the majority of our serious cases are dealt with by jury trials as opposed to the lower courts, the magistrates' courts. On the 23rd of March 2020, the Lord Chief Justice of the UK announced that no new jury trials would start that week, and they wouldn't resume until they were safe to do so. Bearing in mind the particular concern over capacity in courtrooms for social distancing. Now, the halting of jury trials has obvious access to justice implications. Delay will be incurred by postponing the start of new trials. It's already difficult to get a date for trials, which can be 18 months to 2 years in the waiting. So the impact that this will have on the already quite significant backlog is very concerning. And it also has to be remembered that some defendants are in custody awaiting trial. Now, just to think about the practical measures of how a jury trial could work in the context of social distancing, and noting that social distancing is likely to be the way forward until a solution is found to the virus. There are a number of participants in any jury trial: defendants, barristers, the judge, witnesses, security staff, court staff, spectators, and most crucially, the 12 members of the public who make up the jury themselves. Now, jurors usually sit in close proximity to one another in court and retire to a very small room to deliberate in order to come to a verdict. And the advocates sit together in counsel's row. And in the case of a multi-handed trial, it's impossible to put 2 meters, let alone half a meter between them, even in the largest of courtrooms. Similarly with defendants and security staff who will be in close confinement in the dock, as we call it. And that's before we even consider the need for barristers and solicitors to take instructions from their client, often in cramped cells, and with the need to be searched before they enter those cells to take instructions. Now, there may be solutions to all of these problems, but they will take time and technology to solve. And indeed, the courts are looking into viable options as we speak. By way of example, I understand that this month, one of our main courts, Southwark Crown Court, will restart a jury trial in which the jury will be sitting in a different courtroom to the judge and the lawyers to allow them the required space for social distancing. Now, we'll have to see whether this will be effective, whether it even works, and or whether it will be replicated elsewhere. Other options under consideration are using university halls for trials or reducing the number of jurors to 7. The latter option has not been done since the Second World War. I am happy to say that was well before my time. But you have to recall and bear in mind that with all these issues, there will be defendants who are sitting in custody and impacted significantly by the delay or adjournment of their trial. And while courts will accept that custody time limits, and they have the power to accept, can be extended for this exceptional reason, at present, a deprivation of liberty is significantly more onerous and punitive than ever before. And in circumstances where those detained will be concerned for their own safety, as well as for the well-being of their families. And I mean, the idea that prisons are themselves able to implement social distancing is, of course, an absurdity given the overcrowding in our prisons in the UK. And in fact, in some countries, prisoners are being released for this reason. And this is also being considered and rolled out very slowly in the UK as well. But not quickly enough by my reckoning. In the US, for example, I secured the release of one of my clients who was due to be transferred to a UK prison, who was in a New York prison, in a high security New York prison. And we had very legitimate and serious concerns about his welfare, as he was in a cell with someone who was suffering from COVID-19, a cell with 15 to 20 individuals. And we were able, with his US counsel, to persuade the judge to commute his sentence to one of probation. Now, that was a very pragmatic view taken by a US court. I'm not sure we would get the same result were it in the UK. And inevitably, there has been a knock-on effect of all of this on whether or not the police are investigating and charging and arresting individuals. And where individuals are being arrested, police are conducting interviews remotely as well. And in fact, one of my colleagues is doing a remote interview, a police interview with one of her clients this afternoon. Now, as a criminal practitioner, I know that I prefer being with my client in a police interview to ensure that if he is not answering the question, or if he's not doing as well as he should be doing, then there are ways in which I can communicate that to him. How you do that remotely, I have no idea. All that to say that these changes have all happened in a very short period of time, and I'm sure none of us would have believed this to have been possible only a few months ago. But I'm sure that all criminal practitioners will be as concerned as I am about the long-term impact that the lockdown will have on our clients and on their rights and their ability to have a fair, just and open process. Now, I'll pause there as I'm conscious of time and allow any questions at the end, should you have any.
Thank you very much, Maria, for this presentation that was very clear and complete on the situation in the UK. We all face this challenge where we are with these exceptional laws or regulation made under the COVID-19. And in France, we have such absurdity that you have some special regulations that are permitted by these exceptional laws. For instance, you have directors of prisons who require attorneys to certify that they are not contaminated or they are not in contact with contaminated people when they come to visit their clients in prison, where you have no possibility of social distancing and you have no possibility of having a mask, because till this week we had no free access for everyone to the mask in the chemist or the pharmacist or in huge department stores. So that was an impossible situation, and we are challenging those spatial regulations in front of courts, and very often courts cancel these spatial regulations for the laws that will take longer because we will go to the constitutional courts or to special jurisdiction to challenge this spatial legislation. But that allows these spatial regulations that are particularly or absurd, or that limits the rights of the lawyers and especially the rights of the people that we are defending. So we all have to face those special cases. We all know that the delinquents, the criminal rate now is very low, of course, because no one is allowed to go outside. So for drug trafficking, it has taken a complete different way of acting. But we still have, for instance, the domestic violence that are supposed to have a higher rate now, that people are locked down or confined. And we have some cases and some criminal cases. I have to meet tomorrow someone whose father has been killed by a man in some kind of a treason of and possession of jealousy. So kind of domestic violence, extreme, that ended in a murder. But the presentation of the judge was made without a lawyer. That's incredible, but that's the way it happened. So,
terrifying.
Stefan, from Canada, yes, please give us your lights.
My lights, I don't know, but we're getting snow tonight probably. But in terms of everything else, first of all, thank you, Etienne. Thank you, Jerome. Thank you, Maria. Welcome to all. I hope, like Maria said, that everybody out there is fine and safe, because that's the most important thing after all. So I'm going to basically give you an overview of the situation in Canada. Obviously, you know, we're living in every country the same kinds of issues. I mean, of course, with some differences, but at the end of the day, we're all struggling. Our firm at Osler, we are a national firm, so we practice across all kinds of practices. I personally lead the white collar defense practice, and it's, when we say national in Canada, criminal law is federal. So, but procedure is provincially managed, so that the courts are managed by the provinces, even though it's federal legislation, criminal law. So of course there's going to be variations from one province to the other, like here in Quebec, the French Francophone province, as opposed to other provinces in Canada might have different accommodations to the system. So basically, first and foremost, Canada, same thing. We are, of course, courts and people that are in the justice system are subject to social distances directives, and therefore most cases and most courts are closed except for urgent matters, and most cases, of course, are being postponed up to September. The main issue that the courts are struggling with in the criminal practice is two things. First of all, of course, a bit like Amira alluded to, people that are detained. The good news there is we have also introduced a few years ago in most provinces audio links. So this has already been running in terms of allowing people that have been arrested or are detained and need a hearing with a live hearing before a judge. So that is what's going on. That is considered urgent proceeding, of course. But with regards to jury trials, same issues. How is that going to work in Canada is still a big question, especially where, like Maria said, you have 12 jurors that have to sit down. In Canada, in some courtrooms, also we have issues with space. Spaces are very quite scarce. So most of the time, juries are literally sitting on each other's lap. So you can imagine how putting 2 meters of distance between these people is going to work. I'm not too sure. And they're looking at possibilities of moving the jury in another room. But the problem that's gonna cause is obviously we already have scarce space. Courts are struggling to find available rooms in order to have trials proceed. So that will be an issue in itself. So as I said, the big struggle right now we're having, because it's quite new, we have a recent decision from the Supreme Court of Canada, a case called Jordan. Basically, the Supreme Court decided that a trial, the right to speedy trial, which is a constitutional right in Canada, means that from the time of arraignment, a person that is charged has a right to a trial for a real criminal matter of 30 months. So it means that the trial has to be completed within the 30-month period from the time of arraignment. So of course, and when this case came out, recently, of course, a lot of cases got thrown out. A lot of people were outside of the delay. The court had allowed a certain period of adaptation, and now the big concerns from the court is what's going to happen. We're going to see a floods of motions for a state of proceedings under this decision on the basis that people are being detained, and especially for detained individuals. This is going to be an issue that they're going to try to raise. Of course, the case provides for exceptional circumstances. We'll see how that will play out in the courts. But I think this is going to also, because of the weight that this is going to put on the system, I think we're going to see a lot of plea deals in the next few months to a year, where prosecutors are going to be encouraged to try to have plea deals instead of risking to lose a case in the context of an abuse of process proceeding. And as well, also, on the other hand, there is a recognition that jails are not suitable for pandemics. It's a light way to say that. And therefore, there are people that are being released right now. They are releasing individuals before time. And that is because we have also in Canada, maybe not to the extent the United States has the problem, of course, but we have a lot of elderly or older also prisoners. Some of them will have serious health issues, require assistance for their day-to-day activities while still in jail. So they have been looking at that and releasing individuals pending the situation, some cases permanently, some cases under bail conditions. So we're going to see how that plays out. Of course, it is quite a difficulty for any person that practices in criminal law to practice in these conditions. I mean, there are some hearings that are emergency hearings also that can be done. Procedural stuff can be done by phone, which is fine. But to expect that you're gonna have meaningful examinations of witnesses through a camera is, I think, I don't see that. I'm all for technology, but it's going to have its limits in terms of ability, and also the issue of access to justice, like Mira alluded to. I mean, what do you do? Like a journalist, the media's right is also a constitutional right to be present and hear and be present at hearings, criminal hearings. So what's going to happen there once the technology starts to fail? I've had issues where you know, even with the systems that are running right now, you have sometimes audio issues or muted at one point. You know, this is technology that people are trying to master. Last point is, so most of the courts at first level are struggling with this. There's going to be some initiatives locally to try to see how they can expedite urgent cases. And in terms of the appellate courts, they've been trying to move along. Of course, this is a different context. Appellate courts, of course, don't hear witnesses in Canada. They just based on legal arguments from the attorneys, and therefore the appellate courts are functioning. At least some of them. Some of them are start scheduling also, depending on which appellate court we're talking about. So I think we're going to see this continuing for appellate courts. So really, the issue is really at first instance that we are causing. It's causing a lot of problems. And of course, also, you know, more generally, you know, there are also restrictions for someone like myself who has a national practice and has clients in different provinces. We have obviously some issues with travel reduction of within Canada. Travel is not restricted at the moment, but it was looked at in some cases. You were not even allowed to leave a certain region. So how do you provide the service? Lawyers were deemed in some provinces, including Quebec, to be an essential service. But that's one thing, but effectively getting to your client, getting to where they are is a different situation. And of course, for the first time in its history, Canada closed its border to general travel to the United States. So that also renders the situation, as we have a lot of cross-border cases between Canada and the United States. So that's again an issue right there. In terms of enforcement, there is going to be, I think, a flooding of cases of people that are going to be challenging all kinds of orders that were issued by the government in Canada under the Quarantine Act, which is a criminal statute where people risk jail and imprisonment, as well as hefty fines and a criminal record for violating orders, which, for example, applies to someone that would come back from Canada to Canada from traveling anywhere, including the United States, and has not completely quarantined themselves for the 14 days. The Royal Canadian Mounted Police and other police force are conducting monitoring of individuals, and people caught face criminal prosecutions. So you're going to see people challenging that. There's been also a lot of issue in restricting civil liberties, particularly of people that are over 70 years old, and now they're talking about 60 years old, restricting their ability to move around and even leave their homes or their residence. This has caused an issue, with recognition by Prime Minister just yesterday, that it's also causing another unattended effect of COVID, which is that you're seeing a lot of mental health issues now, especially with elderly people that are completely isolated. And that's actually where we're seeing the population is mostly affected by COVID, both by COVID directly, but also by the unintended effects psychologically of that. In terms of, again, emergency legislation, like most everywhere, businesses except essential businesses were told to close down. They're not allowed to function, and that also is creating issue. And in terms of corporate liability for corporations in Canada, like in most common law jurisdictions, we have obviously criminal negligence that can apply even to corporations and individuals, where a corporation does not take reasonable steps, where a corporation does not follow legal obligations, whether under a decree, by regulation, or in the act, and someone dies or is severely injured, potentially COVID, then you would end up with potential prosecution for the corporations. And also, I think in terms of other effects of COVID, we're going to be seeing is there's been a lot of issue with supply chain, especially in the for PPE, for example. You know, there's been a lot of stuff going on, inflated prices, governments and private companies being forced to pay prices that are 10-fold, 15-fold the regular price for those products. So I think you're going to see that also in terms of corporations that have been allowed to delay filing financial statements and other requirements because of the COVID. You're going to see there also, I think, issues. Insider trading has also become a problem in this age. For example, people that had a heads up about a certain type of business that would be considered essential business and started to trade before this information was processed by the public and available to the public. So I think in terms of criminal law, you're going to see a lot of effects. The practice in Canada, like I said, like everywhere else, is quite difficult at this stage. But what we're seeing on the other hand is that criminal investigations are proceeding, and the way they're proceeding is more in terms of background analysis, because again, because of the Jordan decision I mentioned, there's been now pressure on investigators to take more time to build their cases in order to make sure that when it hits the arraignment date, that they're ready to run in terms of the process in order to avoid a potential Jordan application. So this is obviously something that's going to be a problem. There's also, in terms of civil liberties, of course, in Canada, we have Section 6 of our Charter, which provides for the right of mobility within Canada anywhere you want. Now you see restrictions. How is that going to be? How is that going to be challenged? Is also something we're going to keep an eye on. And finally, I would say that in terms of the issues that we're seeing a lot in terms of problems related to COVID are also based on the fact that you have a large portion of the population that is now working from home, and that has also exposed individuals and corporations to heightened risks in terms of cyber attacks, in terms of data theft. We are seeing this happening quite more regularly than before. It was already a huge issue. And in terms of law firms, obviously, this is a priority in terms of making sure that the data of the clients are secure, even if you're working from home, because, of course, that's the kind of information third parties should not have access to. And this has also been a challenge for law firms trying to make sure that their systems are robust in order to avoid these types of problems, because obviously the link is with individuals receiving email, clicking on something, and then potentially infecting the system. So that's another issue. Interpol, for example, has been sending a lot of reminders regarding the risks associated with fraud. We've seen a lot of fraud also with people being called, for example, being told that their family member has been taken to the hospital, they can't visit. Even though Canada is, we have a free system for healthcare, people are getting calls and being told that they need to send a check right away or wire or pay by Bitcoin some money to assist their family member that is caught. So you're going to see all kinds of fraud cases coming up also. So before putting to the floor, I would say, I think nobody knows exactly. I think like anything else in life, I think we will move on and there'll be a post-COVID period. For the moment, I think everybody's trying to adjust day by day and trying to do their best to ensure that the system works as best as possible. But of course, criminal law particularly is quite impacted due to corporations those are entitled to. So I will leave the floor for questions, and thank you very much for your attention.
Thank you very much, Stefan. That was so interesting to have your point of view from a federal country, of course, and the difference between the different provinces of Canada and the restraints of liberties that you are not used to at all in Canada. We are not even, but we are more used to sometimes to have some governments who want to restrain our liberties. We face so many cases, and we will in a second take some questions from the audience, but I would like to point some maybe that ask you as well, Maria and Stefan, if you have to challenge some cases for different matters, different issues. For instance, for flagrant crimes, the everyday crimes. Actually, in France, people are brought to court every day for usual crimes, for everyday crimes. They have no lawyers because they are usually defended by appointed lawyers, and the bars doesn't do any more designation for appointed lawyers because the sanitary conditions are not ensured in court. So people are brought to court when they want an appointed lawyer, they have no lawyers. The same in custody. What is the situation in the UK and in Canada for them?
I can do the UK, obviously. In the UK, I mean, lawyers are considered to be key workers in that respect. So they would still have access to their lawyer or a lawyer. But as I mentioned earlier, that might be done remotely as opposed to in person. And that's not the same as going into the cell and speaking to your client and feeling that you have a secure mode of communication in which to do that. So you still have access to a lawyer, but it's not in the same, there's not the same reassurance, and certainly clients are more guarded in their approach because they're speaking via a means permitted by the authorities. So they still have access to their lawyers though.
Yeah.
And in Canada, I would say in Canada, what you're referring to in France is flagrant crimes. We have summary offenses, which is the equivalent in the US of misdemeanors, lower category types of crimes. Like you said, where people, when they're charged, are usually not represented by or don't have an attorney there. So things to consider in Canada, first of all, is that the right to an attorney has to be obviously given to anybody that's arrested. And when they don't have the money, the officer in charge has to provide the phone number, a free call number, where they can get access to a lawyer right away that will provide at least the basic advice to the person prior to being questioned. But I think to take a step back, I think there is a bit of a reasonable approach that's been taken by authorities, because misdemeanors traditionally are not seen as that serious. So obviously we have another procedure by which misdemeanors can just be the equivalent of being ticketed. So you get a court date later and you never are detained. So they're trying to avoid detaining people right now as much as they can, obviously for safety reasons for the officers, but also for the individual arrested, unless it's absolutely necessary, it's something violent or violent crime. But in most of those cases would proceed differently.
I should also add, from the UK perspective, they've issued guidance to say exactly that, which is they should be proceeding only with the most serious cases, and where there are alternatives to prosecution, they should be seriously considering those for the more minor offences.
Okay, that's interesting. That's not exactly the way it happens in France. On a completely different issues, I would like to ask a question, and it's more general and political, because in France we have much debate this week upon the government wants to pass a law that will modify the involuntary manslaughter crime as for directors of companies and even for politicians, to say that there will be an immunity or an responsibility presumed for those who direct companies who employ people, salaries, and for elected representative who won't be responsible for any COVID case under their jurisdiction. So that's a big debate, because some people say, some lawyer says, oh, that's good because the criminal law is going to be easier and less severe. And some other people say that's supposed to be to avoid any pursuits against directors and against politicians. Do you
So
have
if
this
I can jump on that one, I think in Canada, any like broad immunity for criminal negligence, what you refer to as involved, but here I would think it would be fit more in criminal negligence that would where it would be a total scandal in Canada to have like this broad immunity. To the exact contrary, day after day in the news, people are pushing for public inquiries to investigate where the government failed, where some individuals failed, especially with retirement homes in particular. So I think we have the exact opposite. And in any event, I mean, it would have to be a case by case. The Attorney General would have to justify why they're providing immunity. We can't even phantom that I can't even phantom that possibility from a criminal law perspective. From civil liability, that's a different story. There could be potentially immunity from civil lawsuits, but from a criminal perspective, any attempt to feather the discretions of prosecutors and allow them not to bar them from proceeding with cases would be a total scandal.
Okay, very good.
Same in the UK. I think there would be a public outcry if they even attempted that. I mean, what the government here is sought to do is to preempt perhaps a civil lawsuit. And in the case of key workers who have lost their lives, have already preemptively said that they will be issuing compensation. So they anticipate that there will be fallout once this is all over and we take stock and look at what has happened and what went wrong.
Okay, so I think we have a certain number of questions from the audience. Colette, I think Colette is here and
Yes.
can gather the questions, maybe. I have the question there. I see from Robert Hurst, from Piotr Shosovich, from Adrian Gulati. Can you please read us the questions, Colette?
So first, there is a first question from Jan de Freitas, who said, do we think there will be a lot of challenges based on Article 6 of the European Convention on Human Rights, where hearings have taken place remotely? How quickly could those challenges realistically be made?
Yes. So what do you think? Challenges on the Article 6 of the Convention of Human Rights? Maria, maybe?
Yeah, I can certainly see that in the pipeline, and that's certainly something we would be thinking about if we had concerns about the fairness of the process, and we thought that we wouldn't be guaranteed, that by the measures imposed by the court or the prosecutor. But I think the courts are going to preempt that, and where there is any doubt as to the fairness or issues as to access, I think they will postpone hearings. I don't think they would go ahead if they thought that there would be a situation where that would arise. But we won't know until that process starts. And certainly in relation to the jury trial that's starting again in Southwark, I can certainly foresee that that if it doesn't go the way the defendants want it to go, they might be considering that.
Okay, thank you. We have a question of Robert Hurst that I can't read totally. Will the Court of Appeal eventually be flooded with what is the following question?
Yes, with disgruntled litigants seeking reversal of a remote judgment on the ground of absence of a fair hearing.
Mm-hmm. The courts will be flooded, and they are already in France. I can tell you that many lawyers are challenging the way people are trialed now, concerning the fair trial. Yes, that has started, and probably courts will be flooded with this kind of challenging. Yeah.
In the UK context, where there have been quite a significant number of challenges, are in the restrictions to people's movement. So you can only move if you have a reasonable excuse, and certain people have been charged and convicted when it's later been discovered that actually the circumstances in which they were, or in which the charge was brought, were unlawful. So there will be challenges, certainly, and particularly to the restriction on movement.
And we have
think,
Robert Hurst who says more. He says that in the French legislation, it's permitted under the UIA law, yes. Might there eventually be a challenge in the court in Luxembourg? Yes, of course. And he says, in view of Brexit, the UK has nothing to fear. That's Robert Hurst.
I think we've got a lot more to say, but there we go.
Yes. Stefan, you wanted to answer that question?
I was just going to add very quickly that I think we're going to see, like everywhere else in the world, you're going to see, of course, courts of appeal being flooded. I mean, lawyers are going to be challenging for sure. And on top of it, you're going to see also class actions and lawsuits, and because you can, of course, challenge in court the ticket, but sometimes that's one possibility, because you're also challenging other courts a violation of your charter rights. So that could go separately, and you're going to see appeals, but also I think a charter of rights challenges with regards to those restrictions, and it's millions of dollars in Canada fines that have been issued under these orders. I mean, in Montreal, for example, police officers would. I think now they're relaxing as we're trying to move forward with changes with the confinement rules, but a month ago, people walking together, a couple would be stopped and they would check IDs to verify that they were living in the same address. People in the car, if you had more than 2 people in the car, they would stop the car and check that people live at the same address. And if you didn't live at the same address, let's say people that are just have a relationship but are not living together, they would get ticketed, both of them. So that's thousands of dollars, millions of dollars at the end. So you're going to see challenges for sure.
And also, just to add to that, I mean, in the UK context, you don't have to answer questions. You have a right to silence, but with a reasonable excuse. If you don't answer, you're of course going to be convicted because you haven't given a reasonable excuse. So there will be challenges in respect of that as well.
We have a question, Colette, from Piotr, from our colleague from Poland, I think.
Yes.
But I can't read it.
It said exceptional regulations in Poland introduced an institution of suspension of limitation periods in criminal cases, in fact, for an indefinite time. And he asked, do you have a similar situation in your countries? Warm greetings from Poland.
Okay, so maybe quickly I'll jump in. In Canada, as opposed, for example, from the United States, there is generally no statute barring period for indictable offenses, so equivalent of felonies. Most of the time, some exceptions in some federal law, but as a general rule, for the statutes of limitations for misdemeanors in the United States, or what we call summary offenses, there usually is a period, a statute barring period. I have not heard of any suspension of these, but this will play into what I was mentioning before with the Jordan decision and the right to a speedy trial, which depends on the type of crime, 18 months or 30 months from the date of arrest or arraignment.
Yes. We have another question from Mr. Giulati.
Yes, would like to know how are the office staff coped with the new situation? Are you finding difficulty to achieve the same efficiency?
We all do, I think. Wherever we are, we all do. It's really difficult because we are with our colleagues, with our partners, with our collaborators, we have to arrange the visio conference work, teletravail. We have to organize everything we're going back to work, all of us, next week in France on May the 11th, next Monday. And that's supposed that we have new rules, new sanitary measures made for everyone, of course. So that we are all organizing that. And in the way of financially, that will be a great challenge as well.
Not easy.
Stéphane?
I was thinking you're right. It's absolutely not easy. I think it asks upon all of us to make an effort especially also with our colleagues, our staff, which are also feel isolated, and it's important. So we've done, for example, is on top of connecting for files or matters, we also try to regularly connect on video by chat with our colleagues, the people that work with us, or the staff, to keep them connected, because of course a work environment is a social environment, and when people start to feel disconnected from it, they start to get a bit depressed. And I think, like I said before, I think mental health is also an issue to keep in mind, and all of that is as people are starting to feel very isolated by this process, and it doesn't make it very efficient either. Try your best, and I think we'll see better days.
Yeah,
I mean,
we will. And in my firm, they're doing some wonderful things. Cinema nights with introductions, with everyone watches the same film, pub quizzes. You know, it's incredible how innovative you can be when you have to be.
True, very important. So maybe we have the last question on the control bridge of Schengen agreement. I can say that I can read the beginning, Colette, and the rest.
Do the border controls breach the Schengen agreement?
Yes, it does. No more Schengen. What do you mean by Schengen? No, we have the control on the borders, of course. And in France, under the exceptional state of sanitary emergency, we are banning foreigners to enter the country, supposed to, even from the Schengen area, until the 24th of May. And we are supposed to have 2 more months of exceptional state of emergency until the 24th of July, maybe the 24th of June. It will depend whether the Senate or the National Assembly will prevail, but the government wants it to be till the end of July. So 2 more months of state of emergency, and under the state of emergency, the governments can decide what he wants and on the border control. So the President Macron said that the border control will be limited to people coming from out of the Schengen area, including the UK. Though UK has never been in Schengen area. No, and so people from the Schengen area should be allowed to come to France under the state of emergency, but we don't know yet. There is a question from Yann de Freitas for Maria. Maria's film, please, Colette, can you please read it?
Yes, is Maria's firm's film night witness for the prosecution?
No, it's not. It's something that's much more artsy, Ian.
Good. Very good. To end this webinar, maybe, Colette, we have someone who would like to take the floor with the microphone.
There is the last question from Pedro Barrosa. From your experience in these last few months, did you have any witnesses giving their statements from home by video conference? If so, how can the court certify that the witnesses are not under coercion or without anyone close to them telling them what to say? Not in France, because in France we only have witnesses in court for major criminal cases, you know, for major cases. So they are all postponed. So we don't have the case. No, we don't have to witness to listen to the witness via video conference in France. In the UK or in Canada?
Well, in the UK, it's certainly something that's been flagged, particularly in domestic violence cases, and they haven't found a solution to that yet.
Stéphane?
And in Canada, one thing that they've added as a rule is that only you can get sworn statements remotely, so you don't need to be present to be, if you have an affidavit or a sworn statement to provide in the context of a case, it can be done remotely with the person receiving the oath being not in the same place. And there's been some attempts, more or less successful, of conducting examinations via platforms such as Zoom, for example, or other platforms. But this is really ad hoc. It's not generalized at all. And in any case, a lot of cases are proceeding right now in any event. So this is not an issue. But the question raised was a good question, because obviously it goes back to the whole difficulty of conducting a practice of criminal law via video when you don't know what's going on in the other room. So it's an excellent question that I think it's going to have to be addressed.
So I think that will be the end of this webinar. If there is no more question, Colette? No?
No, it's the last question.
So we have to thank everyone who participated to this webinar. Thank you so much to have taken some time to share with us your experience and to listen to what we had to say in this webinar. It's a good way of maintaining the contact and share the sociability that we all miss. And hopefully we will soon meet again. Thank you very much, Maria, for participating to this webinar. Thank you very much, Stefan, for the same. And we have to think of the next webinar, or not what webinar, maybe the next seminar of the Criminal Commission as soon as possible. Thank you so much.
Thank you to everyone.
Thank you. Stay safe, everyone.
Thank you, everybody.
Bye-bye. Thank you.
Bye.
Thank you,
Bye.